So we're going to proceed just like a normal hearing would take place. I'm going to allow each side to make an opening statement. The county has the burden of proof today. The county is going to present their case first. Mr. Kesselring, you have an opportunity to cross-examine any witnesses that they present. Once the county is done presenting their evidence, I'll allow you an opportunity to present any witnesses or evidence that you would like me to consider, and then the county will have an opportunity to do the same and cross-examine any witnesses you present. And then once we're all done, I'll entertain closing arguments from both sides. The rules of evidence are going to be relaxed today. Again, this is not a formal court of law. We don't go by the formal rules of evidence. The things I always concentrate on that I tell everybody are, is it relevant and is it reliable? If it meets those two things for me and I'm comfortable with those two criteria, I'll consider the evidence. If you want to move something into evidence, make sure the other side sees it first, and make sure I can make a note of if something was actually moved into evidence to preserve it for the record, as I know we have a court reporter here today also creating a record for us. Questions?
You should see it first. Is it very formal that I go there before I go you, or can I just kind of hand it to both of you? It doesn't matter, right?
No,
okay. I just want to make sure.
Informal. Just give them a chance to look over everything.
Sure.
Are there any other questions either side? Mr. Chairman?
I have kind of a question, kind of not more a comment. The deputy has a law enforcement matter that he needs to get to, like, immediately after this, if not before. So I would ask, to the extent that we can, if Mr. Kesselring wishes to call him in his case, if we could call him out of order so he can get to his law enforcement matter expediently, I should say.
We'll get you out as soon as we can.
Yeah. Then I have another matter. When you were talking about the filming, I have two comments.
Yeah, do your thing.
Okay. Well, the first one, I have no objection to anybody filming in here, but at the last hearing we were here, I was confronted after we're taking a break, both in this room and in the hallway. I would just ask that people be reminded that they can film the proceedings when we take a break. I should not have to be confronted in the hallways outside because that's a violation of. We take the position that's a violation of the facility rules, subject to being trespassed, and we don't want to do that. So just if everybody's filming, be mindful of that. And I would object to the publication of my image, likeness, or voice on any social media or platform for any filming that's done at this proceeding today. That's all I have.
Any other questions?
Yeah, I have a few things, if that's okay. Is that okay for me to do a couple preliminary things before
Yes, please, go ahead.
Okay, for the record, pursuant to Florida Rules of Civil Procedure 1.49C, I objected to the referral of this matter to a magistrate, and as such respectfully demanded a hearing be conducted by a duly elected judge. My letter of objection was ignored by County Attorney Janette Knowlton and the Commissioners. I also objected to not being informed of the name of the magistrate that would be hearing my appeal, or even if they were able to find one. I believe this would be more properly called a notice of referral to a magistrate as required by Florida Rules of Civil Procedure, Rules 12.490. This was also ignored. If nothing else, this certainly appears to be a violation of the oath of admission to the Florida Bar, pledging fairness, integrity, and civility, not only in court, but also in written and oral communication. So I kind of challenge the jurisdiction of these proceedings. I believe that would be the correct way to say it. And I'm pretty sure I saw somewhere that a special magistrate is somehow not required to make oath or give bond. I'm certain under whatever rules the county has conjured up, only members of the Florida Bar may be appointed as special magistrates. Can I ask you if that's correct? You have to be a member of the Florida Bar.
Member of the Florida Bar.
Perfect. Okay. So for the record, I'd respectfully ask to read into the record the Florida Bar oath, which includes supporting the Constitution of the United States and the Constitution of the State of Florida, among other things. It does not include supporting administrative rules. May I read that?
No.
Okay. So you're, okay. Okay, all right. For the record, I'd also like to state that in a previous trespass appeal hearing in Charlotte County, the magistrate asked the county attorney if the magistrate was required to read county ordinances as though they are constitutional and reconcile them with the Constitution in making his determination. The county's attorney's answer was, it is. And I have a video of that if you need proof. I don't know. And the following is his statement. I understand that I don't have the authority to rule on constitutional issues, but is it not the case that I am required to read county ordinances as though they are...
Mr. Kesselring, if you have questions about how the hearing is going to be conducted today, I'm happy to answer those.
Okay. That's
You know, the procedure is what it is.
okay.
If you have an issue with how the procedure is conducted today, you have every right to seek appeal in the proper jurisdiction, in the proper court, at a later date. But today, all I'm doing is conducting the hearing as required by the ordinance, and that's what I'm going to do today.
Can I ask one question then?
Yeah.
If it's agreeable with you, I'd like to know specifically who the opposing counsel represents. Can I know that?
He represents Charlotte County.
Is that the government, the county attorney, the commissioners? Who is that?
Charlotte County is the government.
As a government. Thank you. That's what I need. And if I'm allowed to make one quick statement about the thing, my wish is that you would rule based on natural law on which U.S. Constitution is based.
Okay. Well, when you give your opening statement, if you want to say your piece, you can do that thing. If you have any questions about
One more.
proceedings.
A real question, for sure. Lastly, if the magistrate be so kind, would you please explain the proper time and procedure to object, if I have any objections?
When you feel it's appropriate.
Just any time.
Yeah.
Even during closing arguments? I don't...
Sure.
Okay, thank you. That's all I need. Thank you, sir.
Okay. Mr. Chairman, any brief opening statement on this?
A very brief opening statement. I'll try and keep it brief.
Yeah.
This is, again, Untitled Trespass, and we are going to show through Deputy Sterling and 2 videos that trespass is properly issued. Deputy Sterling is going to testify that he was authorized by the county administrator, and he was requested by the county administrator to issue a trespass warning for any violation of facility rules that he personally observed. Deputy Sterling is going to tell you that he was on duty on a certain day, I believe it was June the 13th. He was not at the front desk, he was observing the cameras in a room, looking at the cameras, saw Mr. Kesselring walk in with what appeared to be a ball cap mounted camera. Didn't appear to be disturbing anybody, going about his business, going down the hallway to pick up some public records. That Deputy Sterling went to the public records office where he saw Mr. Kesselring, asked him, are you recording? The response it was absolutely. And Mr. Kesselring decided to talk a little bit about constitutional rights, things of that issue. Deputy Sterling observed him recording, issued him the trespass warning. We're going to introduce several documents that will show that Mr. Kesselring was aware of the new facility rules. He apparently sent blanket emails to all the commissioners objecting to the new rules, claiming it was unconstitutional. We'll introduce the email copies of all the emails he sent each commissioner, along with a link. If you click on the link, it'll show you the link, pulls up the new rules. So he knew about it. So he clearly knew about the new rules. The video that he took that we're going to present shows him actually up in the parking lot, walking all the way down the hallway to the public records office, where he met with the ministerial employee to get his records, and as he meets with the ministerial employee, Deputy Sterling comes in. It's clear that he was videoing. There's not going to be any doubt at all. Not going to be any doubt that he knew about the rule, and based upon the observations that Deputy Sterling had, the admissions of Mr. Kesselring, he trespassed him, and that's going to be really the case. So we're going to introduce the trespass notice, county ordinance, facility rules, 2 videos, and the emails. And I think at the end of our case, you're going to find that the county has proven beyond a preponderance of the evidence that the trespass was lawfully issued based upon our county ordinance. That'll be our case.
Thank you. Mr. Kesselring, now is your opportunity to make just a brief opening statement about your case.
Okay.
Or any case that you'll present.
Okay. Well, good morning, Your Honor. I wasn't allowed to say that before, but thank you for hearing my appeal. I follow the Creator and not a man-made laws that go against His laws. My Creator's given me certain unalienable rights. I'm not a citizen of this world, but a citizen of heaven. But I must try to live at peace with all men. The best way I see fit to function is to not hinder anyone else's rights or allow them to hinder mine. So on June 12th, 2019, at approximately 3:15 p.m., a trespass warning was issued in my name by Deputy Randall Sterling. It was a trespass warning from public areas of the public county administration building and the entire public campus of the public administration building, including the public sidewalk in front of the public building, for a year. This trespass was given for allegedly videotaping a transaction I was allegedly making while lawfully picking up some public records from the Public Records Office from a public records specialist. These were public records that had been worked on previously by the public. Notification was sent that the public records were ready for pickup. Full compliance to all federal, state, and local ordinances and/or statutes were followed. At no time during this transaction did any public employee advise that they did not consent to any audio or videotaping of them. There is, however, a government camera in the office that does record them digitally all day long. There was no warning given to stop audio or videotaping or anything else. No reasonable or prudent person would believe they were violating anything. A transaction with government was documented for valuable information for the public to be disseminated at a later time. I saw it disseminated at a later time. This trespass was executed under a rule made up by the county attorney that is being implemented as though it is law. The county commissioners are well aware of this rule and have not seen fit to either challenge or confirm it through public notice or public input. I don't know, I can't hand out, no exhibits now, right, sir?
No, not right now.
Okay. They were notified by email on 2 occasions, which the county attorney's already stated himself. The emails of which I will enter into evidence if permitted. According to the officer, it was alleged I was trespassed for videotaping and for disruptive, harassing, or unsafe behavior, including conduct which interferes with county employees or county officials in the performance of their duties, or interferes with proper use of the county facilities by others. This is Rule 7 and Rule 9 of whatever they're talking about. The evidence will show that the person in the video should not have been trespassed, disrupted, harassed, or treated in a way that was unsafe to himself or to his constitutionally protected rights by the deputy or any other county employees. I have a genuine desire and an intent to return to the Charlotte County Administration Building, not only in my capacity as a resident of Charlotte County, Florida, but also in my capacity as a citizen of the state of Florida who attempts to instruct my public officials on a regular basis, also as a citizen who frequently attempts to access public records, and even as a journalist and a disseminator of information to the public of materials that would be of interest to them. However, if I do return to Charlotte County Administration Building, I'd be subject to immediate arrest without the proper permissions from Ray Sandrock or whoever at the time is the go-to girl or guy. It's very difficult to get this permission and can cause great hardship, including denying my rights to free speech, freedom of the press, my right to instruct public officials, and request redress of grievances, even my right to renew my driver's license or obtain a permit. At the conclusion of this case, I will ask Your Honor to dismiss this trespass warning for which we're here. Thank you, sir.
Let's knock something out real quick, based on things I heard from both sides. You intend to present, I'm guessing, the trespass warning itself, 2 videos, and those emails you discussed?
Yes, sir.
Mr. Kesselring, are you aware of all those materials?
I believe so.
Do you have any objection to those being admitted into evidence? Because you both talked about them. If you want me to just go ahead and put them into evidence now, we can do that now. And
I'm shown to him, so he has. These are
Thank you.
all the documents that we.
Yeah, I know what these are because I did send those, and I'm okay with the emails to the commissioners.
Okay.
It's the truth.
Okay.
The facility rules, whatever they are, they're posted, so I'm okay with that.
Okay.
This looks like my trespass warning. I'm okay with that.
Okay.
And what is this? This is some kind of a memorandum.
That was I didn't know if it was going to be, really not evidence. I didn't know if the issue.
I object to this memorandum unless I can look at it and find out what it is. I don't know what it
raise
is.
the issue of constitutionality.
Is that okay?
I had that memo again.
Okay. Well, so far as facility rules, your trespass warning, and those emails go, you're okay with those coming in?
Yes, sir.
Okay. Yeah. I'll go ahead and speak.
But there was something else, wasn't there? There was
the ordinance
videos.
is attached. The ordinance.
The ordinance is fine.
Okay. So let's set aside the memo for now.
Okay.
I'll receive the documents and evidence. I'll let the county put on their case. If you have any objections to the videos, before they're played, let me know. We'll talk about those.
Okay.
Otherwise, let's go.
You want to play the videos now or later? It doesn't matter to me what, the videos will also be evidence also.
We didn't talk about objections yet, if I have any. I just need to think for a second. Those are for your videos. Wink.
Okay. So for the county's evidence, Exhibit 1 is going to be a packet of emails from Mr. Kesselring.
Thank you, sir.
You can make that like composite one, there's about 8 or 10
Yes.
pages, I'm not sure on that page.
Yes, that's composite 1 is the emails. Number 2 is the Charlotte County facility rules. County's number 3 is the trespass warning. 2 pages that include trespass warning and the facility rules with boxes 7 and 9 checked off. And number 4 is going to be the Charlotte County ordinance itself. A copy of that.
Objection, sir? Are you ready?
Well, why don't we go ahead and have Mr. Sterling, Deputy Sterling,
Sure.
start his testimony, and then when Mr. Fairland's ready to introduce the videos, you can make your objection.
Sure.
Okay.
Thank you, sir.
Here, or see,
Madam Court Reporter, can you hear him if he's all the way over there? Yes. Okay. Let's do that.
okay, would you state your name and spell your last name, please?
Randy Sterling, Sterling.
And where are you employed, sir?
Charlotte County Sheriff's Office.
And how long have you been so employed?
A little over 5 years.
And what is your position?
Currently, I am assigned to the administration building, Charlotte County Administration Building, which is on Murdoch Circle.
Okay, you are a deputy sheriff?
I am.
You're a certified law enforcement officer?
Yes.
And as part of your assignment to the administration building, what are your duties there?
Provide security for the campus, also any public meetings, commissioner meetings, just basic security matters.
I want to call your attention to June 12th, 2019. I think in the opening I may have said June 13th, but talking about June 12th, 2019. Did you have an occasion to have an interaction with someone who you later learned to be as David Kesselring?
Yes.
Okay, will you describe to the magistrate how you came into contact with Mr. Kesselring on June the 12th, 2019?
I was in the security coordinator office and I was watching security footage at the time. And I noticed him on one of the cameras approaching the public records office with what appeared to be a camera on the bill of his cap.
Okay, now on that day, there was no Board of County Commissioner meeting or any other kind of public meeting going on at that time, was there?
Not that I recall.
Okay. So after you saw him on the video with some kind of camera, what did you do next?
Immediately, then I went to the security desk and retrieved a file I have of trespass notices before proceeding to where he was at the time.
Okay. Prior to that day, were you familiar with Raymond Sandrock?
Yes.
Raymond Sandrock is the county administrator?
Correct.
Did you have a conversation with Raymond Sandrock where he authorized and requested you to issue trespass notices for any violation of the facility rules that you personally observed?
Yes.
Okay. So you obtained the stack, or you went to the stack of your trespass notices. What did you do next?
After I grabbed those, I proceeded to public records, the office in B building,
Okay, for what purpose?
to find Mr. Kesselring.
Did you recognize Mr. Kesselring when he first walked in?
Not immediately.
And why was that?
He had a ball cap and sunglasses on, which I've never seen him wear either that I recall.
You've seen him in the building before, but you just didn't recognize him
Yes.
on the screen. Okay. So you went to the records department. Did you have a conversation? Did you observe Mr. Kesselring in the records office?
I did.
Okay. Was anybody else in the records office?
Other than employees, no.
Okay. Who was the employee who was there?
Michael Wintercorn,
And who was Michael Wintercorn?
one of the public record clerks. I don't know what his title is.
Okay. You spoke with Mr. Wintercorn before, correct?
I have.
Okay, and you know that he's not appointed, correct, to any position?
I can't speak to that.
Okay, but he's not a commissioner, is he?
No.
Okay, as far as you know, he's not an elected official, correct?
No.
And as far as you know, he just took the bar exam as just an employee, correct?
Yes.
He's just working in the records department as basically a records clerk, to some degree, correct?
Correct.
Okay. He's not even in charge of the records department, is it Jennifer Rogers, the person that you would report to?
Yes.
So, when you saw Mr. Kesselring in the office with Mr. Wintercorn, what were they doing? Or what did you observe as you walked in?
I initiated conversation as soon as I walked in, so what they were doing, I don't know.
Okay, well, tell us about the conversation.
I initially asked, who I didn't know to be Mr. Kesselring at the time, is that a camera and are you recording?
And what was his response?
Absolutely.
Okay. Do you recognize that Mr. Kesselring that you observed in the records department recording is being present in this room today?
I do.
Could you point him out and describe what he's wearing?
He's sitting to my left in a white shirt, tie.
I'd ask that the record reflect the witness to identify Mr. Kesselring.
The record just so reflects.
Okay. At this point, we'd like to play a video. Or is there maybe an objection?
Do I get to cross? Or?
No, at this point, he's not finished questioning Mr.
Okay.
Sterling yet, but he would like to play the video at this point.
No problem.
Any objections to the video being played?
Not that I know of.
Okay.
Could you play not the Wink, the other one?
How you doing today?
Now, we evidently, because they had some people come around and
Hello, sir. I'm here. Hopefully this is the right check. I got two invoices for the same thing. They were different. Oh, took the second one. Took the second one. I took the cheaper one.
What to make the check out?
$655. Not I have cash. Not just like five, like last time. You realize you charged me $450 for a CD last time, and you emailed me 5 records.
It's not about
It's not about CDs?
not about CDs.
Really? What is it
How
about?
long it took to review what was there?
Well, that was on, that's here, this says CDs, this says how long, but the other one also has
That's
four.
CDs. That's how long it took.
Pretty sure the last one had a CD
Check.
cost, yeah. Yeah. Pretty sure the last one had a CD charge too. I'll look at it.
Well, if you really are that interested,
I have it, I'll look.
you sure?
Yeah, I'll look it up then.
I'm looking right here, because I don't want to mischarge you if I did. I know it's a line item, but I don't think it was charged.
Maybe not. I know
Mr.
that.
Kesselring, May 31st. Labor was an hour and 3 minutes,
Mm-hmm.
and it was $17.95, no line charge for it.
There's no CD on it?
No.
Okay, I thought I saw a CD on it. Must have been a different one. One of them had $450 for a CD, I don't know what that's about.
Well, it's not a CD. Digital media, CD or DVD
Oh,
falls in that category,
yeah.
and I have a drop down. So the $455 is for a 4 gig thumb drive. There's $360 for a 2 gig thumb drive, 62 cents for the CD.
I was looking at
Yeah, CDs are line items, but if there's not a 1 there or a number there, it doesn't calculate across. You know what I'm saying?
All right, so we got lots of records in this one, hopefully?
There's records.
And the only reason you put it on a CD is because it won't fit on an email, right?
Yeah.
Okay.
Yeah. I don't charge you for my CD. You just email it to you. They not now when I do email it to you, didn't I?
You email the one that only has 5 records, I hope, yeah. This one, if it ever has that many records, you can't send 2 emails? You can't do it separately? I can see why.
Are you recording on our path?
Oh, yeah,
Are you recording?
absolutely.
Huh? I need your identification.
I don't know if you do that for this kind of thing.
You gotta give me something,
Why is that?
because I'm going to trespass you.
You can ask him, can you?
I'm asking you. I'm dealing with you.
Okay, you've dealt with other people and they don't give you a license or anything.
Well,
You say it's okay because I'm alone, because there's not 4
Well,
people.
I don't know you.
You know them?
I don't know who's them. I don't care.
So,
What's your name?
under duress, I'll give you my license. By the way, what jurisdiction or what branch of the government do you fall under? Do you know? Branch of the government? What branch of government does? There's supposed to be 3 branches, there's actually 4, but do you know which branch? Oh, credit card, I'm already paying you, huh? See, but it's gonna take me a minute to find it. Actually, the driver's license, okay. You don't know which branch?
No.
Wow. Because you don't have any jurisdiction to trespass me. You don't have any authority to trespass me.
Okay.
And the county attorney doesn't have any authority to make this a rule. The county attorney doesn't have any authority to give you orders. You work for the judicial branch, actually, just so you know. And the judicial branch didn't make this rule. An individual made this rule. So, knowing that, you no longer fall under whatever they call immunity.
Kesselring?
Yes.
Dude, what? You would.
What's wrong with Kesselring? Don't like German?
Notice you.
You got that ready?
Yeah, that's your copy and that's the CD behind it.
Okay.
These are your, that you place there, just make sure it's all.
Thank you, sir. You have a nice day.
You too. Wanna step out or you wanna stay in here?
It's cooler in here if you don't mind staying here.
Yep.
Nobody gets. There's no air out there.
Just good address for you?
Yep.
Phone number?
941-421-0046.
Mike, what is today, the 11th? Yes, that's 12.
You're doing this under your own cognizance?
What time is it right now?
10:15 p.m.
3:15?
Or did somebody else say, county attorney or Ray Sandrock or?
Well, I wasn't listening to you. What'd you say?
I said, who told you you're trespassing?
Me.
You're just doing it on your own, okay. Good. And why is it you're trespassing again?
You're recording.
Because I'm recording while I'm doing business, recording my transaction with the government because I don't trust them. And you're trespassing me for that, correct?
Sure.
Okay.
Facility rules, your conduct.
Facility rules don't override law, and you're supposed to be law enforcement. You're supposed to be keeping an oath.
Mm-hmm.
You're supposed to be protecting and serving our rights in the Constitution.
I'm serving you with a trespass.
Yeah, I know. It's a violation of your oath, sir. Thank you. And this means I cannot speak to in front of the commissioners anymore or get any public records anymore? Is that what that means?
You will have to make appointments to come here if you wish to do that.
With who? Do you know?
The security coordinator.
Is that Scott? Mr. Scott or something like that?
Yeah, for the security coordinator.
No, you don't know. Okay. Well, you don't work with him then? You don't work with the security coordinator?
Sometimes I do.
But you don't know his name?
We don't have a specified one right now.
Oh, interesting. Can I get your name and badge number, please, sir?
Pretty sure you know, right?
I'm asking you for it. You don't have, I guess you do have to give it to me, but if you don't want to,
Sterling
don't have to.
3028, which is my employee ID because badge numbers don't hardly exist anymore.
And you do work for the sheriff, not the county government, not the administrative branch, right? The sheriff, you're a deputy, correct?
No, G4S.
You're a G4S? Who?
No.
Oh,
That's your copy, you need to leave.
all right, sir. You have a nice day. And my trespass from the sidewalk as well?
No, you're conflict.
What does that include? Please tell me what that includes, because I don't want to trespass.
Well, that's the right way.
Okay.
Everything on this side of the sidewalk, the building department, all these buildings here, everything is going to come off the
The
sidewalk.
sidewalk at the street or the sidewalk in front of the building?
Street sidewalk.
Okay. Good. Won't be seeing you for a while. Have a good one. See what we can do about this. What's that? Oh, yeah, I got it. Yep. Don't say it on camera. Don't say it on camera. I better go though, I'll get arrested. I can't afford that right now. Maybe next week. trespass on my own building. Really? That would make more sense. At least you wouldn't have that oath that you took.
I have a couple questions and follow-ups on the video.
Seeking to admit this?
I am.
Any objections to this being?
No, sir.
This would be, I'm gonna call it, the county's number 5. I'm gonna call it video A, which is camera footage. Okay, Mr. Chairman.
And we have a thumb drive that we'll be able to provide to you. Okay. Deputy Sterling, so you issued a trespass warning to Mr. Kesselring on June the 12th based on the authority and the request from Ray Sandrock, correct?
Correct.
Now, we saw that video. Does that truly and accurately reflect the transaction between you and Mr. Kesselring on June 12th, 2019?
Yes.
I don't have any further questions for this witness.
Now's your opportunity if you'd like to cross-examine Deputy Sterling.
I would like to. I'd like to start by asking a few questions from what just happened. You trespassed me not only from the inside of the building, but also the sidewalk on the outside of the building, correct?
Up to the street sidewalk, you're allowed to be on the street sidewalk.
Do you understand that the county actually gives you permission to film on that sidewalk outside the building?
That's the county's.
It's in the
stance
facility
on
rules.
that.
But you trespassed me from the whole place, even where there's specific permission to film. I just was curious if you knew anything about that, or...
I'm not sure what you're talking about.
It wasn't one of my questions, but I just thought I'd ask. Yes, okay, so my questions, let me just find those. Okay, sorry, I have to cross-examine you, I don't have anything against you.
Mr. Kesselring, when you're turning that way, I can't really hear you.
How about this?
That's
Good, okay.
Would you like me to sit there?
That'd be great, thank you.
Be good with that?
That's perfect. Uh-oh, hold on one second. Is it really? Give me one moment. I just wrote some notes on a piece of paper that is about, no, sorry. There we go, okay. Are you an elected official?
By definition that I understand, no.
You're not an elected official, yes or no? You're not,
No.
right? No, okay, thank you. Did you sign an oath?
I did.
I don't know if you'll take it, but I'd like to enter this into evidence.
I'm happy to go through his exhibits, just want to expedite this, and I might be able to stipulate to many of them. No objection.
Can you read this, please? Just your...
Hold on, I'm gonna have, this is going to be Mr. Kesselring's Exhibit 1, which looks like a oath of office. Okay, go ahead.
Okay. I, Randall Sterling, do hereby solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States and the state of Florida. That I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of Deputy Sheriff of Charlotte County on which I am about to enter, so help me God. Thank you, sir.
Do you take this oath seriously? The oath to uphold it, you do, thank you. Would you ever violate your oath?
No.
Okay. What would cause you to violate that oath? Anything?
I'm not willing to, no.
Not willing to, okay. Do you believe you should support and defend the First Amendment of the Constitution? It's part of it,
Sure.
okay. What would cause you to not support and defend the First Amendment? Anything?
I'm going to object to this line of questioning. I'm sure that there's some peripheral
This
relevancy.
goes to credibility, sir, of the witness.
We need to focus on,
He's a witness.
I'm very aware he's a witness, thank you.
I'm sorry.
We need to focus on the facts and circumstances of that day. I'm gonna let you ask a few more questions,
Okay.
but we need to get to the point of what happened that day. If you believe something was done improperly, ask about it, okay?
I will. I was just kind of leading up to it, but okay. I'll do my best to shorten it if you'd like.
Thank you.
Let's see. Okay. Have you ever read the First Amendment?
Not in its entirety.
Okay. Okay. Good enough. That gets something out. Okay. I'll try this one. Do you have a strong belief that you are not violating the rights of the people and your oath when you trespass them for filming?
I'm gonna.
Do you believe you're not?
Check. I think we're going down the same path with this line of questioning.
Nothing about the oath, sir? I can't ask any more questions
No,
about that?
I think
I've got a lot of other different questions that are
I'm
more
going to say
specific.
again that I've said in previous hearings, okay? The witnesses are concerned with the facts and circumstances factually of what happened. If you're going to ask him, Mr. Sterling, if he believes he did anything legally improper,
I understand.
not for him to determine, that's my call.
Oh, okay, okay.
But if you feel he didn't comply with the ordinance or did something procedurally incorrect in applying the ordinance, you can ask him about that. But as far as his legal oath, the Constitution, whether he violated any laws, that's for me to decide.
But I need to ask him the question so you can get the information, no?
About the facts, yeah. About what he did, what he said, what he saw, all that good stuff.
Okay. You demanded my license twice. That's a fact, okay? You detained a person, the license was handed over to you because you were the big guy and you have a gun and whatever, for whatever reason it was handed over to you under duress. Please articulate reasonable suspicion that a crime had been committed for which you detained me and demanded my license.
I'm going to object to that line of questioning because he's not charged with a criminal offense. This is not a criminal court.
Sustained, this is not a criminal proceeding.
Okay. As a sheriff's deputy, you are law enforcement, correct?
Correct.
What law was violated?
Again, I'm going to object. He's not charged with, say, county ordinance. Well,
I
he wants
think
to
you-
phrase it to a violation of county ordinance. I have no objection to it going down that line.
Okay. Just rephrase whatever Deputy Sterling, whatever led him to make the decision to
Okay.
find the violation.
Okay. What's your definition of probable cause? Would that work?
Deputy Sterling, why did you trespass, Mr. Kesselring?
It was based on the county ordinance that the commissioners adopted that you violated.
Okay. Are you law enforcement or county rule enforcement?
It's under county ordinance, which we are also allowed to enforce ordinances.
But it's a rule, not an ordinance. It's a rule.
It's based on an ordinance.
No, it's not, but, okay.
I'm going to object.
Sorry, I can't argue.
Let's
I
go.
can't argue. Sorry,
Let's go.
I can't argue. Let's see. And you also said that you would support the Florida state constitution as well, right? Not just the U.S. Constitution?
Yes.
Thank you. Okay, as a trained law enforcement, do you see a danger in a camera or a, what do they call it, a videotaping device?
I'm going to object to that. It's
See a danger?
irrelevancy.
Okay, he's here for security reasons, okay. Do you believe that videotape recorders are illegal?
Objection, irrelevancy.
Sustained.
We already know where you were. You were not near the public. You were upstairs. Where were you when, I already got it, but let me clarify. Where were you when you decided to trespass me?
The security coordinator's office.
Can I have the name of the security coordinator?
Objection, irrelevancy.
Do you know the name?
The county doesn't have one at the moment.
Okay, thank you. Okay, this is good. In the video, you appear to be quite comfortable about issuing a trespass all by yourself without contacting anyone higher up. Yet when well, the other part doesn't matter, but why would that be? You were doing it, it said you were doing it on your own on the video. And in other circumstances, you've actually, I don't know if I can say that, but you've gone up and said you had to interrupt Ray Sandrock. They've had signatures. I've got copies of other trespasses where there's Kelly Shoemaker, there's Ray Sandrock. Only your signature. Why is that on my trespass? Why is it different for me?
Policy change within the sheriff's office.
Yet somebody signed, okay. Why would it be different the next day?
You can take that up with my supervisors.
Because there was a hearing in here, I don't know if I can say that, but Susan Hutt, hers was signed by other people as well. Mine wasn't. and somebody before me was. So how can it be different each day? Is there a policy? Is there actually a set policy on how to trespass people?
There is,
What is it?
I mean, it's multiple pages, I can't recite it to you.
Who's supposed to sign these trespasses?
Issued to the public?
Yes,
I mean, it varies in each circumstance.
it does. How can it vary? Why would it vary? Our people are all the same. I'm
The
sorry.
county administrator, his designee,
Okay.
that's how it's worded.
Well, then why would you have to interrupt him to get his signature for another trespass?
I told you policy
I'm
change.
gonna object to
Okay.
this line of questioning.
All
The
right.
other people are not relevant. The only issue is whether he was authorized and requested by Ray Sandrock, which empowered him to issue it. When it was done on other people, it doesn't really apply.
Your Honor, the relevancy of the policy, though. The policy.
I think we.
You got it, though. You got the
I
information.
understand.
Okay, that's fine. Oh, I've heard you say I'm just doing what I was told. Who has given you the order to trespass each time? I'll ask you that again. It's a little redundant, but
It is redundant. I
It's been told.
object.
did someone give you an order to trespass me directly?
Ask one more time, last time.
Last question.
No, last time you could ask that specific question.
Who ordered you to trespass me?
Policy changed, and I didn't have to.
Okay.
Things that occurred in my presence.
Okay. Do you have a general knowledge of police body cams or cameras in general?
Somewhat, I've never used one, but I've had in-car ones before.
But you spotted a camera, you said, right? You must have seen it and known it was a camera, or whatever it was, the video tape recorder, or whatever you think it was, right?
I mean,
Saw
I've
something.
learned enough through you guys.
Okay. Show you some pictures and see if we come up with. Okay. This is a picture of a camera, a digital video camera. There you go. Just look a little like the camera you saw out the side. Out the side?
Maybe. I'm not positive.
Not positive? Okay. It's a digital video camera. I'd like to put that in evidence if I can.
Any objection?
Possibly, if he's gonna stipulate this was the camera he was wearing, what purpose is it being offered for, I guess? If he's gonna say this was the camera he was wearing or one similar to this, fine. If this doesn't, if this is just some random photograph from Amazon, then I have an objection.
A camera, oh, I'm sorry.
Okay, go ahead. But
Cam-
if we have a stipulation of that this, the camera like this, I'm fine with it.
Oh, that's fine. I'm fine with that. The camera.
Are you agreeing, Mr. Kesselring, this is the same or similar camera from June 12th?
I asked him and he said,
Well,
didn't know.
Mr. Chairman's asking you to stipulate. Tell me what's important about this camera. Why is it evidentiary value?
This camera is a digital video camera. Won't hold a tape, can't fit a tape. Okay? It's too small.
Understood. Why is it of evidentiary value to the allegation that you committed a trespass on June 12th?
Because I was trespassed for, make sure I get the words right so you guys can't get me.
No one's out to get you, Mr. Kesselring. I just want to know
It can be
what
done.
evidentiary value this picture has.
I'm gonna find out for sure. On the facility rules, what I was trespassed for.
Mm-hmm.
Right, should be right here, hopefully. Number 7, audio or video taping anywhere inside the county buildings.
Understood.
This does not take an audio tape. It's not an audio tape device. It's a digital
Well,
tape device.
I don't doubt you for a second on that.
Okay.
But I need to know why this picture that you've handed me is relevant to whether or not you committed an infraction of the ordinance on that date.
The person in this trespass, that's on the trespass, was trespassed for that reason, carrying a camera probably like that. Looks like that, right?
I didn't pay enough attention to it.
Okay. Well,
If Mr. Kesselring wants to represent this camera that he was, what we're asking you, if you were wearing a camera like this, or similar, doesn't have to be this exact one, something similar to this, I have no objection. If you were wearing a body cam like Ms. Hutt, maybe I might, but at least if the camera on your belly or cap looked like this, or was similar, I'm fine with it. But if you were wearing a different camera, then I might have an issue. That's all we're asking.
My representation, including on the video, you can see it actually, that
Not gonna make a big issue.
okay?
If he's representing with like that, that's
It's a digital video camera. That's what that
close
is.
enough for government work. I'm fine.
And that's the one that it was being trespassed for, or close.
And I'm going to enter this as Mr. Kesselring's number 2, which is
Okay.
2 pages, a picture of a digital camera that
It shows the specs and the size on the second page.
is
It's
similar.
very small.
That is similar to the camera that was played in the video footage, county video A.
So a camera about that size would fit on the bill of the hat, as far as you know? Yeah, okay.
Yes.
This is Exhibit 21, and people would remember this if not by the picture. It's a picture of a digital video camera. Now, was the camera on the bill of the hat that size?
No,
Would it even fit?
no.
Would it fit around somebody's neck or anything like that? Because there's a big tape. Is there a tape? Would you know if there's a tape in here? There's a tape. You ever seen one of these big old ones?
I don't believe so.
They don't make them anymore. Yeah, they don't make video cameras like this anymore. They don't make them. Okay, I couldn't even find one when I looked for one. Okay, but this is can I put that into evidence as well? That this is not what was on a hat of the person trespassed?
No, I don't believe that's all.
Okay. Do you believe a camera with a tape in it this big, you already asked, but would fit on the bill of the hat?
No.
Thank you. That's all I needed. So, did you ever witness anyone, audio or video taping, in the Public Records Office of the County Administration Building on 612 or at any other type of videotaping?
I'm going to object to that as to relevancy. If the question is other than him, the objection is relevancy. It doesn't matter if others were or were not videotaping or videoing. He saw Mr. Kesselring.
What was your question?
Has he ever seen anybody videotaping in the County Administration Building on 6/2? And that would include me. I'm an anybody.
On 6/2?
6/12/19. 6/12. The day of the trespassing
Go
question
ahead,
here.
Nancy. Did you see anybody videotaping on June 12th?
Videotaping.
As I understand your question, it's a technicality and a definition.
Mm-hmm.
So,
It is.
as it's written, as I understand it, yes, you were.
Did you see anybody digitally videotaping on 6/12/19 inside?
Putting those two together, that they're the same.
So is that a yes on the second question too?
Yes.
Okay. Two different terms? Okay. Okay, a camera, a video camera big enough to hold a tape would not fit on the bill of the ball cap. And you said the camera was affixed on the front bill of a cap. Did you witness the person in the video doing anything disruptive on 6/12 at anywhere in the building?
No.
Disruptive. Did you witness this person harassing anybody?
No.
Did you witness this person behaving unsafely?
No.
Did you witness this person interfering with county employees or county officials in the performance of their duties?
Not directly.
Is that a no?
Sure.
Okay. Did you witness me interfering with the proper use of county facilities by others?
Say again?
Did you witness me interfering with the proper use of the county facilities by others?
Like, as in you were bothering other people?
No, just like I said, because that's in the trespass. That's rule number 9 that you trespassed me for. For interfering with the proper use of county facilities by others.
No.
No, thank you. Did you witness me doing anything in rule number 9? Those were all the items in rule number 9.
No.
No, thank you. Don't need that. So why did you check off that I violated rule number 9?
Consistency,
Consistency.
and you interrupt county business when these matters have to be dealt with.
Really? Okay. Consistency. That's interesting. So do you believe that do you believe that trespassing me for rule number 9 or trespassing anyone for rule number 9 is a truthful statement?
I object to that question. Well, his personal beliefs are irrelevant.
Oh,
Was it a truthful statement?
Out of consistency with others and disrupting county business and having to deal with the issue.
So have others, since you said it, have others violated those rules when you put rule number 9?
Yes.
Most of them?
I don't recall
Doesn't matter.
exactly how many.
Okay. So, somebody was trespassed for rule number 7 and 9, and the deputy just admitted that they did not violate any of 9.
Now enough time for argument.
Oh,
Let's
sorry.
keep-
Joe, I'm sorry, you're right.
You're doing fine.
Sorry.
Keep the questions.
Okay. So who places you in the administration building?
My supervisors.
Is it not the court system, or the courts?
I'm under the court.
You're under the courts, and you're in the administration building. Who do you directly report to, and who gives you your orders?
My direct supervisor is Sergeant Cochran
At the court or at the sheriff?
at the courthouse.
At the courthouse. Okay. So why weren't you at the courthouse?
It's just where I've been assigned.
Okay. And why are you at the administration building?
It's where I've been assigned.
To do what, sir?
Security.
Okay.
Where I've been assigned.
Security. Hold on, let me write that. Who wrote the rule you were enforcing?
I
Objection.
don't know exactly.
Didn't ask if he knows.
If you know the answer to the question, you can ask. If you don't know the answer to the question, answer best you can.
I don't know who it is.
Does law enforcement enforce rules or laws?
I'm going to object to that question.
Based on what?
Because whether he's enforced rules or laws is irrelevant. He's been charged, as he testified before, with enforcing the ordinances. This gentleman's charged with violating an ordinance. So the question is, does law enforcement for the sheriff's office enforce county ordinances? Is the more proper question.
Just answer the best you can.
Can you re-ask, please?
Sure. Does law enforcement enforce rules or laws?
Laws.
Just laws. Thank you. So, following that line of questioning, what law was violated?
An ordinance.
An ordinance? Which ordinance?
The facility rules are based on an ordinance. I've already explained that.
And do you have direct permission from the sheriff to enforce anything other than laws?
Objection, relevant.
Answer the best you can. Let's go.
One more time.
Do you have direct permission from the sheriff to enforce anything other than laws?
I have permission to enforce the facility rules, which are based on an ordinance,
And that's from the sheriff?
or his designee. I don't know how that chain of command works and who makes the rules.
Okay. And you took an oath to the Constitution. Do you take an oath to the people that are giving you these orders, the county attorney?
Object to that, relevant.
Answer the best you can.
No.
So will you follow any order given?
No.
Why were you unwilling to give name and badge number the first time I asked?
Objection, relevant.
Overruled.
Okay.
Answer the question.
You're well aware of who I am.
I didn't know your badge number, just for...
I don't agree with that, but
I don't. Why were you at first unwilling to tell me which agency you worked for?
that was a snide remark.
Do you work for G4S?
Nope.
No. Why would you tell me you work for G4S when you in fact work for another agency?
I'll just explain that.
Okay. Can you tell me which agency you definitely work for?
Sure. County Sheriff's Office.
Sheriff, okay, thank you, that's what I need. And who were you representing at the specific time of the trespass at that moment?
Say again.
Who were you representing at the specific time of the trespass at that moment?
Sheriff's Office.
Sheriff. Interesting. I don't need to make a statement on that, just the questions, right, and I'm done?
Questions only at this time.
Let me make sure there's nothing else. That's it, sir, thank you.
Any redirect?
Real briefly, you're employed by the Charlotte County Sheriff's Office as Deputy Sheriff, correct?
Correct.
And you were assigned to the administration building by your supervisor, correct?
Correct.
And you've been authorized by your supervisor to interact with the county administrator, correct?
Correct.
And the county administrator has authorized and requested you to trespass anybody that you see violating the facility rules as they are incorporated into the county ordinance, correct?
As long as I personally observe them.
Yes. And you personally observed Mr. Kesselring making a video recording, correct?
Yes.
And he admitted to you that he was making a video recording in the records department, correct?
Correct.
Okay. And that's why you trespassed him, correct? You issued a trespass warning.
Correct.
Okay. I don't have any further questions.
Okay. Next witness?
I don't have any further questions for him. However, Mr. Kesselring wants to call him in direct case. I would ask that you be allowed to take him out of order so Deputy Sterling can call.
Okay, let me ask you this for sure. Do you have any other questions for Mr. Sterling, for Deputy Sterling? If you don't have any other questions for Deputy Sterling, I'm going to release him so he can go about his business.
I have no more questions, Your Honor, thank you.
Okay,
Thanks.
thanks, Deputy.
All right, thank you.
Mr. Fairman, any other evidence you want to present?
I have a video that's ready to play, and then that would be all of our evidence.
Okay. Go ahead.
And so that you know, this is the same video we played before. But my vote for second. Some of this has Ms. Hutt on there. There's like a small snippet. I would just ask to play the whole thing rather than delete portion of Ms. Hutt.
It's fine, play
Okay.
Of the county building, and what happens if you do? Are you recording?
Absolutely.
Okay. I need your identification.
We do that for this kind of thing.
You gotta give me something,
Why is that?
because I'm going to trespass you. But is that violating your constitutional rights? Accused reporter Harvey Jackson asked that question to the two people cited for trespassing.
Should you be allowed to record video in a public building?
Are you recording?
Absolutely.
David Kesselring thinks so. He picked up records from the Charlotte County Administration Building on June 12th, wearing a small camera on his hat. But that's when a deputy issued him a trespass warning.
I need your identification.
So does Susan Hutt. And just one day later, Hutt wore a body camera while picking up records at the same building.
What is my crime today? I feel like I'm being suppressed. My freedoms are being questioned.
Kesselring and Hutt are 2 of 8 people cited for recording audio or video in county buildings since a new rule went into effect May 6th. It prohibits anyone from recording in libraries, county offices, jails, and buses without permission from the county administrator, with the exception of public meetings. Were you aware of the rule?
I was. I figured I've been a model citizen.
The county said it wouldn't provide an on-camera interview for legal reasons, but told us the new rules are part of a, quote, lawful county ordinance and protect the safety of employees and visitors. Hutt and Kesselring argue it's a violation of the First Amendment.
This county uses the Constitution for toilet paper much of the time.
They both plan to appeal their trespass warning and hope others will stand up for their constitutional rights.
People have lost most of their natural rights. Most people don't understand that.
The county says some of the trespassers received multiple warnings, and the person violating the trespass warning may face arrest. In Charlotte County, Erica Jackson, Wink News, now.
County Board makes security upgrades to City Hall and other city buildings in 2017 after a man recorded videos of city employees working and posted them on YouTube. That man also received a trespassing citation and is not allowed to return to City Hall.
We would move that video into evidence. Any objection?
No, sir.
Then that will be county's number 6. I'm going to call it video B, which is the news story. Any other evidence you wish to present?
No, that is all our evidence.
Mr. Kesselring, the county has rested their case. Now is your opportunity, if you would like, to present any witnesses or any evidence you'd like to present.
Okay, let's see. The first piece of evidence and you just bear with me, and I appreciate your help so far.
Yeah.
I don't know what's evidence and what isn't sometimes, so the first thing I have is a copy of...
I'll give you the law school definition.
Okay.
Evidence is anything that tends to prove or disprove a factual allegation. So it has been alleged that you violated this ordinance. If you have something that tends to prove or disprove that allegation, that's evidence I'll consider.
Okay.
If you want to make an argument about something was fair, something's not constitutional, something's not legal, we'll do that later.
So you don't want the First Amendment of the Constitution as evidence?
No, I don't.
Okay, thank you.
I'm very familiar with it.
And probably this too. This is a very good argument for that, but that's the same thing, right? It's from Patrick Henry.
I'll glad to hear it later.
Okay. And the Constitution of the State of Florida, still nothing?
Not evidence.
Okay. This definitely should be. This is a statement from the state attorney that we have the right to do that and makes that law null and void. So do all the other ones, but...
I'll consider that as argument later.
Okay, argument. Florida statute, same, right?
I'll tell you this, we have something in a regular court of law that we refer to as taking judicial notice of certain things. You can bypass evidentiary standards by judicially notice certain things that aren't really subject to controversy or aren't subject to reliability or those other checkmark boxes. Things like state statutes, the Constitution, things that nobody can argue whether they're relevant, reliable. I know what the law is, I can go find it. I know what the Constitution is, I can go find it. Mr. Fairman's not going to argue to me that's not what it says, that's not what the Constitution is, because I can just go look it up myself. So I will take judicial notice of every applicable law, from the Constitution to the Bill of Rights to the First Amendment to Florida statute. And we'll do it that way.
I just wanted to be sure, so I didn't bypass something.
No problem.
How about the county ordinance?
I've already got a copy that the county's number 4 is a copy of the ordinance, so I have that.
I wonder if does it look like this, sort of? I mean, I want to make sure it's the same one.
I actually think it does. So you got a little star in the top left corner.
Yes.
June 28, 2016, written at the top, handwriting. Yep.
Thank you.
Got
Okay,
it.
that's good. And where's my list? 7. You have the facility rules up there?
Yes, that is my number 2 from the county.
Perfect, okay. And let's see. How about the Charlotte County? Oh, well, you may not have this because there's some stuff related to the homeroom charter that I'm going to argue. Would you like, can I put that into evidence, the homeroom charter? This is county issue, this is a county administrative.
You said it's something related to the homeroom charter. What is it?
It has to do with,
What is it? Is it an article? Is it a
it has to do with what they have to follow.
Yeah, I know, but who wrote it?
It's their charter. It's the charter for the county. It's like the county constitution is what it is.
It's another one of those things.
You can look it up, so that's okay.
I can look it up, so I'll take additional notes.
It's not as easy to find, so I just thought I'd say.
No problem. I've got plenty of access to all those documents.
Okay, I have a stack of emails here, and they say in their facility rules that you can get permission to go in and do certain things.
Is this the same stack of emails?
No, not at all. It's a lot bigger.
Okay.
This is trying to get in to actually have my rights, exercising any rights or getting any documents or speaking in front of commissioners, anything.
Okay, what we're going to do, take those emails, set them to the side just for the moment. Just pull them out separately just for the moment, because I'm going to come back to them.
Okay, thank you.
What else you got?
And do you have my the trespass warning with my name on it, with this little signature and stuff?
Yes, that was number 3. That was the county's number 3. They gave me that. The one specifically issued to you.
I also have 2 other trespass warnings that are different than mine, that are been procedurally done differently than mine. Could I enter those into evidence?
Tell me a little more about it.
Let me find
Who were they issued to?
Find them real quick.
Were they issued?
So I can see. Okay, this first one was issued to a guy named Ian McGuire, who you may be familiar with. Most people around here are. and it has a couple of other witness signatures on there besides, doesn't even have Sterling's signature on that one.
Okay, what's the other one?
And the other one is Susan Hutt, and it's got Sandrock's signature and the deputies.
Tell me why those are relevant, like we talked about, that tend to prove or disprove your allegation.
One was done before the, can I say things he says, the witness said? Am I allowed to?
Yeah, he's already said it.
He said that there was a policy change apparently before I got there, but this one was done before I got there, this one was done afterwards.
Okay. Mr. Chairman, do you have any objection to, for that limited purpose of showing the difference in signatures? Do you have any objection to those coming into evidence?
Yes, I don't see the relevancy for that. The issue becomes, was Deputy Sterling authorized and requested to issue the trespass warning by the county administrator? He testified to that. Any other whether a different procedure was done a week before, a month before, other people have no relevancy. The sole issue is the trespass warning issued to Mr. Kesselring.
I understand your argument. I think those two trespass warnings are relevant, and I think they're reliable. I don't think they're fakes or doctored up. I'm going to accept them into evidence only for that limited purpose. I don't care about the circumstances of why they were issued. I'm only going to accept them just for the purpose of looking at who signed them and when, and the differentiation like you outlined.
Okay.
That's the only reason I'm going to take them.
Okay on that one?
Yeah.
Thank you, sir.
So that's going to be number 3 and number 4.
I hope it can work.
I only have one. I only have Ms. Hutt. Do you have?
I've done them both, I'm just doing them one at a time.
Okay.
I'll be right with you.
Is that going to be a composite of 3 and 4?
Number 3 is going to be Ms. Hutt. Number 4 is going to be, who was it, Mr. McGuire?
Yes, sir. Yes, Your Honor.
Okay, going down your list of documents, what else would you like me to consider?
I have a memorandum from Ray Sandrock to county employees, and I believe he's telling them to violate the law, and there was something else in here.
Are you aware of this memo, Mr. Fairman?
I am. It was introduced in Ms. Hutt's case, and when I looked at it, it's like, I'm not sure of the relevancy. It doesn't hurt, from my standpoint, it doesn't hurt, it doesn't help, but I'm not sure for what purpose it's being offered. Ray Sandrock clearly prepared it, but I don't know how it's probative is really my question.
Do you have any objection?
No.
Okay.
All right, I'm not.
Number 5, Mr. Kesselring's number 5 will be the memo from Mr. Sandrock.
So, hang on. Let's see. And this is the Florida statute. This is going to be easier for you on what I had in there. I don't know if you want it or not. Maybe you could connect it to it.
What's the statute number?
817.49.
Okay. That's another one of those things that's uncontroverted, indisputable. I'll take it under judicial notice.
Okay. And I have some internet searches here of synonyms of the word public officials, which is very pertinent to my argument. But
internet searches is something I'm not going to consider as evidence just because I don't find them
that's fine.
reliable.
I also have a road gauge thesaurus, and my scanner broke, but I have an entry from here that I'd like to use.
You can argue it to me.
Perfect.
When the time's right.
Okay. Well, yeah, you have a thesaurus. I'm sorry. Getting there. Got those. Oh, the incident report of the trespass.
Do you have it?
I do. Is that okay?
Sure.
Number 24.
Is that for your trespass, the June 12th?
It's for a trespass issued to me by Randall Sterling.
On June 12th.
On
issued here today?
June 12th, 19, yes.
Okay, why don't you, have you seen it, Mr. Fairman?
The incident report.
I portioned yes and no to make sure this is actually not on this form, but I've sure.
Yeah.
No exception, that's fine.
Okay.
And I'll take the incident report as Mr. Kesselring's number 6.
And you already have the copies of my emails to the commissioners. Got that. Can't use that. I have some emails showing, and this is important to my case, but that the video I believe it's commissioners and stuff. Oh, it's Knowlton's one of them, and she's the one that writes it. But
Okay, I want you to take that pack of emails and set them aside with that previous pack of emails I told you to set aside.
okay, gotcha. I have the definition of videotaping from 5 different dictionaries.
Nothing.
Okay, I can use that in my argument, though, right?
Sure.
Okay. I think that's about it. And then I have some videos that you may not take, but I'll ask anyway. Trying to prove arbitrary and capricious on this law. I don't know if I'm allowed to or not, but I've got videos of all kinds of different things happening. It's just the whole thing is arbitrary, and I can't do that argument yet. But
Yeah, unless they're videos pertaining to your specific trespass. So, like obviously the video that came from the camera footage, and the video from the news story that pertained to where you were on the news story. Unless it's pertaining specifically to your trespass, I'm not going to admit it.
even though we have Susan Hutt's thing in there, I have a video of her trespass.
Yeah, I admitted that trespass, not because I cared about why she was trespassing, but because of who signed it. Because you told me, the important part was who signed it, Sandrock versus Sterling. That's why.
Also where she was, and that's on the video.
Yeah, I don't
Okay,
care
you don't
about.
care? Okay, that's fine.
Yes, sir.
I think that's it. Let me just check my videos real quick, make sure there's nothing else I can use. And I believe that is it.
Okay. Then I have for you, document-wise, Mr. Kesselring, the oath of office, the picture of the camera, Ms. Hutt's trespass, Mr. McGuire's trespass, the memo from Mr. Sanderock, the incident report, and then I'm going to take notice of the Charlotte County Charter, Florida Statute 817.49, the First Amendment, and the U.S. Constitution. What I'm going to do now is I want to take a little 10-minute break. We've been going for a minute here. Actually, we're going to take, well, you got to tell me how much time you need. I want to take 10 minutes. Those emails I told you to set aside, I want you to show them to Mr. Fairman.
Okay.
I want to give Mr. Fairman a chance to look over them.
Sure.
When we come back, I want you and Mr. Fairman to tell me, or I want Mr. Fairman to tell me whether he objects to those being admitted. If he does object to those being admitted, I want you to be prepared, Mr. Kesselring, to tell me why they're relevant and why they should be admitted.
Okay.
And then, once we get past that, if you want to call, I don't know if you're going to call any witnesses, but you'll have a chance to call any witnesses, including yourself, if you would like to testify on your own behalf. So in our 10 minutes, let's think about those things. If you need more time, just let me know, but we'll come back in 10 minutes.
Okay, thank you.
Do you have a second? Can I mark on this?
That's your copy.
That's my copy.
Yes, sir.
I don't mean to be difficult, but I'm not sure why any of this is relevant. All these emails, they all appear to be attempting to get the security coordinator's name, phone number, or contact information, things like that, all after the date of the incident. And what we have to focus on is on the day of the incident, what is the day of the incident. So I'm not sure why things, the security coordinator's identification. I understand you want to file an appeal. Apparently you were able to file an appeal, which is why we're here today. So I'm not sure why any of this is relevant, but I'm willing to listen if you can tell me why it's relevant.
I don't mean to be difficult, but I'll tell him why it's relevant.
Well, he's trying to tell us to work it out. If you can convince me it's relevant, I'm happy to agree to it, but I just don't understand how this has to do with what he has to decide. So, I understand your frustration in trying to find...
Should there be any frustration?
That's not why we're here today. I understand, I read this and I see that you're frustrated, you want to know who's the security coordinator, and I want to contact him, so I do my appeal, I want to get in and do my business.
I just want to do business.
I understand that. You're preaching to the choir. I understand what you're saying, but I'm not sure for purpose of what he has to decide, what it has to do with why we're here today.
The rule states that you can get permission and get in. It doesn't say that they're going to do that.
I understand. Yeah, but, okay, we'll just have to, you go ahead and tell him, and we'll let him decide, okay?
Yeah, I understand.
Okay, all right, I understand what you're saying. Okay, thank you, sir.
Thank you.
Okay, we are reconvened. Both parties are present. The county and Mr. Kesselring are present. Gentlemen, did we have enough time to go through everything, or do you need more time?
Probably, I should be okay. I was looking for a couple of, I literally just walked in 30 seconds ago, but that's okay. We're fine on time.
Okay.
I object to the documents more just on relevancy. I've looked through them, and they purport to be.
I need to back slide that.
Okay.
Thank you. Okay, which ones are we objecting to?
All of them.
All of them? Okay.
Yeah, they purport that
Is it relevancy?
yes, relevancy.
Okay, tell me why they're irrelevant.
Can I read something from the ordinance real quick so that I can tell you what the relevance is?
Sure.
It says, if there is no other reasonable alternative location to conduct necessary business or exercise such First Amendment rights, and this is from the ordinance, not the rule, within the 1-year time period, respondent should call the security coordinator at a certain number, 941-764-4922, who will arrange temporary access. Well, first of all, that's dangerous. It needs to be in writing. If they're going to arrest you, you should get it in writing, not on the phone. But there isn't no security coordinator. He even said there isn't one right now. The witness said there isn't one. So how can they have a rule like that and say you could call to get in? All your rights are gone. You can't. You can finally get them, but it's really difficult, almost impossible. And there isn't one, he said, during that time. So how could I?
So is that the purpose for the emails?
Yeah.
Okay. I don't find that tends to prove or disprove the allegation that you committed a violation of the ordinance. If you want to argue that somehow renders the ordinance unconstitutional for some reason, I'll entertain that argument when we get to that point. But I'm not going to accept the emails as evidence because I don't believe they're relevant from an evidentiary standpoint.
Sure.
Okay.
No problem.
Any other? I think you made it through all your documents. Is that right, Mr. Kesselring?
All my evidentiary documents, yes, sir.
Okay.
Yeah.
Did you have any witnesses you wanted to call for testimony?
No, sir.
Did you want to testify on your own behalf?
Absolutely not.
Okay. Then, is there any other evidence you'd like to present?
I don't believe so, sir.
Then, at this point, if both sides are ready, I'll go ahead and let both sides make their closing statements. Mr. Chairman, are you good? You want a little more time?
Don't
bother me if you need 5 more minutes to get some stuff together.
That's fine. I'll try and do it if I may just say, give me 30 seconds to look for a document if it comes up.
Yeah, go ahead.
But I think I can start now. I think I can get through it without looking for the document. Depending on what Mr. Kesselring has to say, I may want to rebut it with a document. I don't know what he's going to say, but
Okay.
I
Let me say this.
Yeah.
Mr. Kesselring, County's going to go first with their argument. You're going to give me your closing argument, and I'm going to hear a rebuttal for them because they have the burden, so they get the last word on it.
I object to that. There's always been a time back for the other person. I thought
No.
the accused gets
No.
the second. Wow. Okay.
That's the county carries the burden, so they're going to get the last word. That's the way the court system works. That's the way the process works. Just not out of the ordinary. I'll cut down on time a little bit and let you all know when we talk about the definitions of audio and videotaping. I don't interpret that to mean there's a need for an actual VHS or tape to be put in a mechanism with a magnetic strip. I don't think that's required. So if there's going to be any arguments about a requirement of a physical tape inside a device with a magnetic strip or something akin to an actual physical tape inside a device, I don't find that the ordinance requires that. So we can dispense with those arguments. Any questions? Okay, Mr. Chairman?
Thank you. I think I can be brief on this. The matter before the magistrate is whether the trespass warning issued to Mr. Kesselring was properly issued. It's a strict violation offense, as I've said before. Really have to look at two things. Was the warning issued by an authorized person? The answer I suggest is yes. We heard the testimony from Deputy Sheriff Sterling where he said that he had a conversation with Ray Sandrock, the county administrator, who's empowered to delegate that decision, and delegated it to Deputy Sterling. He authorized him and requested him. I specifically asked him those two questions. If tracking the ordinance, did he authorize you? Yes. Did he request you? Yes. That's all we have to show. And then you really have to, the next prong, you have to look to see if there really was, it was issued for valid reasons. So the question becomes, was Mr. Kesselring videotaping in the presence of the witness, Deputy Sterling? Did he see that? Did he have a valid reason to issue it? And the answer is obviously yes. There's no dispute. The video that we played shows him in his car all the way through the building, up into the records department. He's videotaping Mr. Wintercorn. He's videotaping in the hallway throughout the building. He admits to Deputy Sterling, the first question when Sterling walks in, are you videotaping? Or are you videoing? I really can't recall whether he said videotaping or might have said, are you recording? And his response was absolutely. That in and of itself is a violation of the facility rules sufficient to justify the issuance of the trespass warning. It occurred right in the presence of the deputy. The video of the Wink TV confirms it. He doesn't deny videoing in there. He admits to the officer or the deputy that he's videoing. Clearly, he was videoing in violation of the rules. It's really a strict liability violation. And it doesn't matter. Mr. Kesselring, by all measures, appears to be law-abiding, that he wasn't disrupting. That portion, I would agree, is very, very weak as far as the disruption that he caused by videoing. He wasn't confrontational as he did it. He was a gentleman in the hallway. He was a gentleman with Mr. Wintercorn, but he still can't record Mr. Wintercorn or that transaction. And the offense was the actual violation of Rule 7, videoing in the building when the rules clearly showed he was unauthorized. And the evidence we've submitted showed that he clearly knew that he wasn't allowed to video. There may be, this wasn't accidental. He disagreed with the rules and consciously violated them. Days before, after the ordinance was enacted, and prior to the date of this offense, he was sending out emails to the commissioners, which we've produced, saying, I don't like this rule, it's unconstitutional, and he chose to violate it. And if you look at the link, he actually copies Rule 7 in the email to each of the commissioners, and he copies the link. If you click on that link or follow that link, it's going to take you to the facility rules, and Rule 7 is highlighted. So it's a matter of, it's a clear-cut case of authorization to issue it and a deputy sheriff to justify the trespass. So for that reason, I would ask that the appeal be denied, the trespass be upheld.
Let me just ask you point blank. Are you sticking with the Rule 9 violation?
No.
Okay.
No, I don't think I don't think there's a Rule 9 violation. I'm not.
Okay.
I'm not going to argue that there's a Rule 9 violation.
Then we will. I'll go ahead at the end today. I'm just basically going to make a finding, no Rule 9 violation. So if you had any arguments towards a Rule 9 violation, don't worry about them. Let's confine it just to the Rule 7. Okay. Mr. Kesselring, your opportunity to make a closing statement.
I don't know if this is the right time, but I would like to move that we strike the witness's testimony. On the video, he told an untruth about G4S. He also told an untruth about number 9 when he crossed that off on the rule for consistency's sake, and that can't be any law that you violate people for consistency. It has to be something that actually was done. Also, he said something about, he mentioned the ordinance, and it wasn't the ordinance, it was a rule. There's difference between the ordinance and facility rules. They're not together, they're separate.
Is that your argument?
That's my motion. Is that a motion? If I make a motion, I can just go
No,
on?
no, I'm not going to go back and strike any testimony
Okay.
or do anything.
Thank you.
We'll just-
That's all I want.
Yeah.
Yeah, thank you. Got to try, huh? Good. So I have a few points. I'll just go through one point at a time.
Sure.
I know you mentioned in a previous time that you'd listened to constitutional arguments, and it's been stated everywhere that you're, well, you know that.
Sure.
So, okay. So, the First Amendment to the United States in regards to the first supposed violation checked off on the trespass issue, which is rule number 7. The First Amendment, just really part of it, Congress shall make no law abridging the freedom of speech or the press. And just to support the original intent of the First Amendment, I'd like to read a quick quote from Patrick Henry. He was in the ratification convention in the beginning, and they were talking about the First Amendment. And he said, "The liberties of the people never were nor ever will be secure when the transactions of their rulers may be concealed from them. The most iniquitous plots may be carried on against their liberty and happiness." This was an argument for the First Amendment, for all the amendments. The facility rules employed by Charlotte County government, written by Charlotte County Attorney Janette Knowlton, her staff, and others, with knowledge of the Charlotte County Commissioners, to stifle the constitutionally protected activity of videotaping, is a direct and blatant violation of the First Amendment. The county can't just do anything they want. They have to follow rules. There are some rules they need to follow. The Charlotte County Facility Rule 7 is unconstitutional on its face and as applied because it impermissibly infringes on the clearly established rights to gather information about what public officials do on public property, and specifically the right to record matters of public interest as protected by the First Amendment, which is incorporated against the states with its subdivisions by virtue of the 14th Amendment. I'll not ask the magistrate to rule on anything new, but simply use the Constitution and reinforcing case law to make your decision justly. That's all I'm asking. And let's see, case law, yes. I have a little bit of that. Give me a second. That should be right here. Yes. I have Smith versus the City of Cummings, which I'm sure you're familiar with.
I have that case.
You're good? You need it?
No, I've got the same thing.
Got it for you anyway, just in case. I'd be prepared if I could. Okay. The citation, you don't want the citation or anything for the record?
No, I have it.
Okay.
I've presented to him several times.
Yeah. Year 2000, it was heard by our own United States Court of Appeals, the 11th Circuit, that's us. It is binding. The following is a broad holding, if not the broad holding. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. Okay? Any person or attorney that argues that public officials are only elected politicians like county commissioners, I believe is using fabrication. I don't want to say anything bad, but Smith versus City of Cummings was about the filming of police officers. I don't know if police officers are elected elsewhere, but they weren't elected in that situation, and in that most important case, they were not elected. They were public employees. Okay. Furthermore, if any person or attorney would like to argue that this is only applied to law enforcement officers, realize that part of the video in evidence is a digital video recording of a law enforcement officer. The same law enforcement officer that was here today is a witness. The fact that filming was not only done of public officials, but specifically of law enforcement officer, makes the case fit perfectly within Smith versus Cummings. Just to clarify, our rights don't come from case law or even the Constitution, they come from our Creator. Hopefully you know that. But they're natural to us. That's why this would seem so unnatural to most people. But it's also protected by, the right is protected by the Constitution. And I'm using case law for your sake. And the First Amendment protects the right to record government employees engaged in public duties. Recording government officials engaged in public duties is a form of speech through which private individuals may gather and disseminate information of public concern. This is exactly what's being done on the video that's been offered as evidence. This can be seen from start to finish on this entire video of a transaction with Public Records Office. Information was being gathered about what public officials do on public property. These activities were, as they would say, videotaped, or they were digitally taped. They were not only for documentation, but also to express to the public. This was done in public buildings where the public was free to come and go, and public officials were being documented. The right to film was being expressed. This was also being done to monitor public employees to ensure they're doing the right things for the public. A public transaction was being documented for the purpose of expression at a later time. The video entered into evidence was captured from YouTube. The transaction video of the transaction had been expressed at a later date. A transaction was being documented. This was specifically mentioned back in the day by Patrick Henry. The specific word transaction was used. The Commissioners Ken Doherty, Bill Truex, Stephen R. Deutsch, Chris Constance, and Joe Tiseo, their attorney Janette Knowlton, and their county administrator Ray Sandrock cannot, with a whimsical stroke of a pen, unbind binding case law for any reason. More importantly, these same people cannot abolish or even suspend any part of our United States Constitution. I move this trespass be dismissed. The rule being imposed is a blatant violation of the Constitution and binding case law. And if not, I'm not done.
Yeah, no, I'm not going to agree.
Okay, thank you. Okay. Since I don't get the last say, I'm going to have to do some more. I was going to cut it out, but I'm only guessing that my opponent may argue time, place, and manner. And just in case, this facility rule created by the county attorney and others also violates even the exceptions that the courts have created in their belief they have the authority to restrict our constitutional right to document public officials in public places. In other words, Charlotte County has gone way past the restrictions put upon the people by the courts. According to the courts, my First Amendment rights described above, that I just described, are subject to reasonable time, manner, and place restrictions. The Charlotte County facility rules are an unreasonable restriction. For said restrictions to be reasonable, they must be content neutral, tailored to a legitimate government interest, not broader than necessary to accomplish said interest, and must leave open ample alternative channels of communication. All four conditions must be met. The county has not shown that it has a legitimate interest in restricting video recording within public buildings where the recording doesn't obstruct or impede the orderly operations of the county. The video of the trespass in question speaks for itself. It neither obstructed nor impeded anything. Nor could the county likely show a legitimate interest in restricting such recording, as no public official acting in performance of their official duties has an expectation of privacy. I don't take too much credence again in the case law, but since most lawyers do, I'll cite some. Department of Ag and Consumer Services versus Edwards. It's the District Court of Appeals of Florida, 1st District. It's for argument. Would you like that case?
Sure, if you want to.
Okay. This is Department of Ag versus Edwards. It's highlighted. You're welcome. Thank you. So, an officer with the Florida Department of Agriculture Inspection Division, who was not an elected official, was placed under arrest for recording conversations between himself and other public officials, his superiors, Pittman, O'Brien, and Wells. This arrest was supposedly for violation of the Florida statutes regarding interception of oral communications. Well, the Florida Constitution contemplates that public business is to be conducted in the sunshine. This is from the case. Reasoning from this open government premise and the fact that all persons claiming an expectation of privacy in this case were public employees acting in furtherance of their public duties, the hearing officer concluded that any statements made by Pittman, O'Brien, and Wells in performance of their public duties were not privileged, hence no reasonable expectation of privacy attached to those statements. For the record, these were not elected officials. They were public employees. Any person or attorney that would argue that public official is only an elected politician like county commissioners using fabrication as an argument. While I'm at it, I would like to add a little more documentation to the definition of public employees. From the Rogace thesaurus, if you'd like me to show you, the synonyms are public official, public servant, public functionary. None of those other people are elected. And from the Cambridge Dictionary, this is a definition: a person who has official duties, especially in a government or even a political party. So there's a sentence here they use: the visitors were met by a functionary who escorted them to the director's office. Maybe the director might have been elected, but I'm sure the person escorting him wasn't. Government functionary, even that has government ministers, as he mentioned, and civil servants. So from some other quick and easy searches of the internet, I don't even take them, but synonyms for public official: public officer, government employee, bureaucrat, an administrative officer, a public official. Could be any of these and more. Of course, the strongest argument is that Smith was filming police officers that were not elected officials. They were government employees. To reiterate, the county government could show no legitimate interest in prohibiting filming in public buildings. There's also no way the county could show a legitimate government interest in stopping anyone from documenting transactions and legal activities on public property in the most dependable and efficient manner available to them, which would be videotaping or digital videotaping. Got it? Going too fast, I think.
No.
Further, no citizen has any expectation of privacy. No citizen does either, in things they knowingly expose to the public. So if a citizen doesn't and public workers don't, nobody does in that building. So members of the public have no expectation of privacy in the halls of a public building. If another person creates a disturbance or harasses another person because they don't like a camera, the person doing the actual disturbing or harassing should be trespassed. This includes public employees. Again, there should be no need for case law, as any prudent person that lives in our current world knows there's cameras everywhere, especially at the Charlotte County Administration Building. You have no expectation of privacy in things you normally expose to the public, even in your own home office. When you walk into the public building, you just can't claim an expectation of privacy. Katz versus U.S. Would you like that one?
I want you to present to me any case that you feel is right.
Here's the right one I'm reading. Okay, so that's Katz. This was in regards to private, conversations, this is a quote: conversations in the open would not be protected against being overheard, for the expectation of privacy under the circumstances would be unreasonable. And then this was a landmark Supreme Court case, just for your information. For the Fourth Amendment protects people, not places. What a person knowingly exposes in the public, even in his own home or office, is not a subject of Fourth Amendment protection. So they're not protected from anything. As such, prohibiting recording in areas of public buildings in which the public is free to come and go would not meet any legitimate government interests. Furthermore, even if the county could argue that it has legitimate interest in barring recording and gathering information on government activities which do not interfere with its operations, it could not likely show that such a restriction as written does not infringe substantially more speech than necessary to accomplish said interest. How is video recording in and of itself a deterrent to any legitimate government interest? Lastly, assuming, just for argument's sake, there was a legitimate government interest and that it did not infringe upon substantially more speech than necessary, such a restriction fails to leave open ample alternative channels of communication. Court of Appeals, 7th District. This is Alvarez versus Civil Liberties Union. If I can find it here. Should be it. This is the whole case. This is Alvarez versus Civil Liberties Union. And it's in the 7th Circuit. It's just for argument. Audio and audio-visual recording are uniquely reliable and powerful methods of preserving and disseminating news and information about events that occur in public. Their self-authenticating character makes it highly unlikely that other methods could be considered reasonably adequate substitutes. This rule leaves no ample alternative channels, the rule in Charlotte County. We aren't even allowed to access any of the many cameras already permanently installed in the county building that videotape every move we the people and most of the government employees every minute of every day in Charlotte County Administration Building. Even if we had access, there's no audio. That is my first point. So at no point you'll dismiss this while I'm arguing. I'll just keep going then. Okay. So these are shorter. Point 2, the Constitution of the State of Florida in regards to the first supposed violation. The trespass rule created by county attorney and being implemented as though it is law also violates Florida state constitution. This is, you don't need the Florida Constitution, but this is Article 1, Declaration of Rights. Freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. And the rest isn't pertinent right now. This explains the rights of the people, and I'm sure I'll hear no illegitimate arguments as to abuse or defamation. Our right to videotape is not only protected by the U.S. Constitution incorporated by the 14th Amendment upon the state, but is protected directly by the Florida Constitution. It also protects the right to assemble. The people shall have the right to peaceably assemble, to instruct their representatives. There's no obstruction to this in the state constitution. They're not allowed to obstruct my right to instruct my representatives, which they're doing. And to petition for redress of grievance, same thing. There are no restrictions. Clearly obstructs these rights. Furthermore, our right to videotape in public buildings has been strongly reinforced by our own state attorney. In reply to a Punta Gorda felony warrant request directed at a person videotaping in a public building, which Punta Gorda Police Department tried to sell as wiretapping, Richard T. Simpson of the state attorney, 20th Judicial Circuit, replied, after saying it wasn't a violation, a citizen's right to film government officials in the discharge of their duties in a public place is a basic, vital, and well-established liberty safeguarded by the First Amendment. This is what our own state attorney said about filming in buildings. It's our own 20th Judicial Circuit. This warrant was in regards to filming of Phil Wickstrom, Human Resources, who is a public employee in Human Resources. To repeat from Department of Ag versus Consumer Services, the Florida Constitution contemplates that public building businesses to be conducted in the sunshine. Okay. State statutes.
Could you just slow down a little bit since we're reading? No, I got all that.
Just getting hard. I'm sorry. Thank you. I need to go slow. As Charlotte County Ordinance 2016-027 makes no mention whatsoever of videotaping, the direct changes made by the facility rules in an attempt to revise or amend Ordinance 2016-17, it is an attempt. The facility rules start with the statement, the following conduct is prohibited by County Ordinance 2016-027. This is an attempt to revise or amend that ordinance by the county attorney and others in violation of the Florida statutes. It says procedures for adopting ordinances. Each ordinance or resolution shall be introduced in writing and shall embrace but one subject and matters properly connected therewith. The subject shall be clearly stated in the title. No ordinance shall be revised or amended by reference to its title only. Ordinances to revise or amend shall be set out in full the revised or amended act or section or subsection or paragraph of a section or subsection. The original county ordinance adopted by the Commissioners has no prohibition of constitutionally protected videotape, has no permission for the already constitutionally protected right to videotape outside the building. And I don't know if you knew that from the last case, but we have permission, even with all this other stuff, to go ahead and film outside the building. This was added by the county attorney and others contrary to the procedures in the Florida statutes. I propose this was a revision or amendment to the county ordinance. It was not originally included in the ordinance or in the original facility rules, but is now included in the facility rules. The facility rules begin with only the title of the ordinance. As stated in 166.041, no ordinance shall be revised or amended by reference to title only. From my understanding of the facility rules were written by county attorney, her staff, and others, and never was a revision or amendment to the ordinance ever set forth by our elected commissioners. No vote was taken by our county commissioners. 16, sorry, I need to look and see what 16 is. If I find it. Oh well. Just one more broken statute I found by my untrained eye being violated was written by the, this is the, did we take it into? Yes. The memorandum. Okay. It was written by the county attorney and others and never brought before the public by the commissioners. Charlotte County government has given training to their employees to violate the rights of the people to gather information about what public officials do on public property. They also distributed special cards to their employees that instructs them to act like they're upset about video cameras by telling the person behind the camera, the one who they are supposed to be serving, that they don't give their permission to post the information being gathered about what public officials do on public property to be shared by other taxpayers. The biggest problem with this thing, the most obvious violation, if a facility supervisor is not available, call 911. This is entirely and absolutely illegal. 911 is only for emergencies. There's no emergency here. This is a crime under Florida statute 817.49. Whoever willfully imparts, conveys, or causes to be imparted or conveyed to any law enforcement officer false information or reports concerning the alleged commission of any crime under the laws of the state, knowing such information or report to be false, in that no such crime had actually been committed, which it hadn't, shall upon conviction thereof be guilty of a misdemeanor of the first degree, punishable provided in S775.082 or S775.083. Ray Sandrock and his assistant Kelly Shoemaker have ordered all employees to commit crimes. The moment they call 911, they are calling to report a crime. Photography is not a crime. Now the facility rule itself. In the actual ordinance, Section 3, it states severability. There isn't one in here. I'm not going to go through that. Again, underlined in bold is stated, the following conduct is prohibited by County Ordinance 2016-027. Videotaping never mentioned in the ordinance. The ordinance mentions facility rules, but since the unconstitutional prohibition of videotaping is not included in the original ordinance and was created by the county attorney, it's circular. I don't know what the term would be legal, but if this is upheld, it would give the county attorney unfettered power to make up anything she likes, including no Kesselrings, no dissenting opinion allowed, or even no blacks allowed. If you notice from the copy of the facility rules included in the evidence directly from Janette Knowlton, the facility rules were adopted June 28th, the same day that the actual ordinance was adopted. At the bottom you can see the date amended is May 6th, 2019. I have exhibits of those. I don't know if you want to see those. You said that would be okay. This amendment substantially changes the ordinance by putting anyone with a video camera or even a smartphone in danger of being disturbed and harassed by a county deputy and issued a trespass warning. This substantial change was done without input from the county commissioners or the public. There is no mention in the original ordinance about audio or videotaping. It only mentions actual crimes and things that might harm others, not tools to document what public officials do on public property. Further, even if it had been included in the original county ordinance, the county ordinance cannot override the U.S. Constitution, the Florida state constitution, or established state law of any kind. All right. Anyone need a break? You okay? Okay. County charter. I'd like to discuss that. There's various violations of the charter in the creation of these new facility rules. A prudent person, Your Honor, would conclude that a magistrate would have the authority to rule on county matters, as this rule has been rented by the county. The building in which this room is located is controlled by the county. The magistrate is paid by the county, I believe, and hired by county attorney who wrote the rule in question. The trespass has been issued by the county and the rule is made by the county. Section 1. Charlotte County shall be a home rule charter, county, and except as may be limited by this home rule charter, shall have all county and municipal powers of self-government granted now or in the future by the Constitution, not inconsistent with general law. A prudent man would conclude that a magistrate in a county administrative trespass appeal hearing would certainly be able to rule on the constitutional standing of a county rule being implemented as though it is a law. The legitimate powers have been granted by that Constitution. Smith versus City of Cummings clearly establishes the constitutionally protected right to film in public buildings. The facility rule prohibits the same, violating the people's constitutionally protected right. I'm sorry, this is so long, I could have skipped some. But the chain of command for making legislation, especially legislation so obviously violating the protected rights provided by this Home Rule Charter, and shall have all powers of local self-government, not inconsistent with general law or special law adopted by the vote of electors. The adoption of all ordinances shall require the affirmative vote of a majority of the total membership of the Board of County Commissioners. It was pointed out clearly in my previous point that the ordinance has been substantially changed by the county attorney. She has no authority under the county charter to change, create, or revise an ordinance. She has done so in the creation and changing of the facility rules. Any new rules not coinciding with the original county ordinance that she has created or changed are illegitimate and unenforceable. Furthermore, even if this rule was constitutional, how can anybody but the commissioners create a new crime, a new class of crimes, and new criminal penalties for these crimes? The county attorney's office is not a legitimate body. The county attorney's office does not stand alone over all other branches of government. This should be known by anyone that's ever heard of the term separation of powers. What else we got? Of course, the second part of the trespass rule is an outright lie. It's not true. I don't need to go through that, so I'm going to skip that. Again, I'm not a trained lawyer, but I'd like to argue a little bit about this arbitrary and capricious, which goes to this rule. Doing something according to one's will or caprice, and therefore conveying a notion of tendency to abuse the possession of power. Arbitrary, according to Black's Law, revised 4th edition, which I have here, 4th edition, means in an arbitrary manner, as fixed or done capriciously or at pleasure, without adequately determining principle, not founded in the nature of things, non-rational, not done according to reason or judgment, depending on the will alone, absolutely in power, capriciously, tyrannically, despotic, without fair, solid, and substantial cause. That is, without cause based upon law. And it isn't. It's not based on law. They do it differently every time. Who knows? Who even knows how it's going to be done? The abuse of discretion or otherwise not in accordance with law, or if it was taken without observation of procedure required by law. The opposing attorney will most likely object to any video, and they did, okay? Arbitrary, vague law. Sometimes this rule implemented as though it's law. It's applied. Sometimes it's not applied. Sometimes it is.
I'm not objecting to the video, but at this stage, I'm not sure that I've heard a whole lot of argument as far as the evidence, and we take a position that the constitutionality and these issues that you've raised are outside the scope. I mean, I'm happy to I don't know if you're waiting for an objection from me.
No.
I'm happy to sit here and just have a standing objection to any of
I'll note your standing objection.
I'm getting near done. You
Yeah.
want me to finish?
I want you to just finish your arguments.
Okay.
That's what I thought.
Sometimes it's implemented in certain circumstances, and sometimes not, even when the rule was broken 4 times as much by somebody else, so you just don't even know what they're doing. I have a video that I have entered into evidence with 4 gentlemen. I didn't, but a short time before my transaction, or the one in the thing, had entered the administration building to videotape. Deputy Sterling told them they were breaking the rules. He called the county attorney, who stated, according to the deputy, that she would pass on the trespass. She'd pass on it. The deputy said, have fun. These were 4 people with cameras, and they shouldn't be trespassed, but neither should anybody else. The county sheriff has revised their policy to not follow the illegal rules of the county attorney. Sheriff was trespassing us, their bosses, at the behest of a memo sent by the county attorney. They've since recanted and no longer trespass anybody on specific grounds that they're videotaping. Just a videotape from there. Arbitrary, capricious, my own forms of evidence, county officials' whimsical enforcement of warning, including the trespass. I believe you allowed the emails? You didn't allow them. You didn't allow the emails. Okay. But I had a stack of emails, and the county attorney resulted from my attempts to simply hand in a piece of paper and have a copy made. They finally agreed to allow me on the property. I won't go through this whole thing. It took me from Tuesday to Friday to hand in my appeal, and it was Friday about an hour before they closed, an hour before my thing. I believe they purposely stalled me. I went in to get some public records, and they said, we don't have anything available until 2 days from now. When I went in to do either one of these things, there was a guy sitting at the front desk who was always there, who just did it. So they were just making this stuff up to make it difficult. So that part of the rule, it says that you can go in and do business with permission, is crazy. They don't even know who the security coordinator is, And again, calling them is dangerous. I want to get it in writing. And to get something in email from them, it takes all week. And if you need a public record right away, or you need to speak before the commissioners and instruct them, I may know that morning. And they'll say next week. You know, you can't do that. None of this can be done. Let's see. A couple of logical things. The cameras are those that are supposed to be represented and served by the occupants of the public buildings in Charlotte County. Should create no more disruption than the multitude of cameras hanging all over the public buildings themselves, being monitored by who knows who, because we can't find out. They're a mystery. The security coordinator's a mystery. If county employees are so upset with the people's cameras, what about government recording them all day? Why are they so upset about we the people, and not upset by government cameras to keep watch all day long? How is the lens on a non-governmental camera more disturbing or harming than the lens on the county's cameras? If there is any chance that a law or rule could possibly take away the free exercise of any right, and especially those already protected by multiple documents, those laws or rules must have minimal standard of going through certain processes. There was no legitimate process in the case of the prohibition of the video recording, and there doesn't seem to be any process of the trespasses either. And I think I'm about done. I handed these in, but I didn't give this thing. My trespass was improperly issued. If you look at Ian McGuire's warning, you will notice that Kelly Shoemaker and Janette Knowlton's signature on the trespass. If you look at Susan Hutt's warning, you will notice Ray Sandrock and Randall Sterling's signature on the trespass. If you look at this other trespass, you'll notice that only Randall Sterling's signature is on the trespass. He specifically says on the video he's doing it of his own accord. He says he has permission, but he had to get the signatures the next day. And the day before, he had to get signatures apparently, but not on the day that he gave it to me. That's just arbitrary. That's crazy. You have to have some kind of policy. They went to great lengths, the county attorney and Sterling, to say that she caused a disturbance because Ray Sandrock had to be interrupted in the middle of a meeting to sign a warning, which obviously he doesn't. Specifically stated on my video, he was issuing a trespass completely on his own. And I believe I have everything.
Very good. Mr. Chairman?
I will be very brief. We've heard a lot about the U.S. Constitution. Everything Mr. Kesselring said is for another form. This is not the place. And I've provided a memorandum on that issue. It's for you, sir. I've provided this previously to the magistrate, which addresses the issues to be determined today, and unfortunately for Mr. Kesselring, this is not the forum for that, for the constitutionality of the issues to be decided. The other issue and that was a lot of what I heard was 90% constitutionality, and I'm going to address the other 10%. Mr. Kesselring, I believe, if I can synthesize Mr. Kesselring's argument, I think, is the county adopted these new rules. Didn't used to be against videotaping, video recording wasn't in the old rules that other people had. They moved the goalposts on us. The document that I've provided to you is part of our administrative code, and the simplest way of saying this is the board adopts the ordinance. The county administrator, the county attorney have been delegated that authority to review and update those facility rules. And that's in there. If we just look under policy and responsibility, especially responsibility, county administrator, part number 4, county administrator in conjunction with the county attorney is responsible for reviewing and updating these procedures and facility rules. So as much as Mr. Kesselring would like to believe that this was improper, illegal, that they changed the rules in the middle of the game, county administrator and the county attorney can do that, and they have done that, and I've provided the authority for how that was done. Improperly issued, there is nothing that prohibits, that requires witnesses, other statements. The trespass warning can be issued based upon delegation from the county administrator, which the ordinance clearly sets forth. He authorizes and requests that it be issued, and the testimony was that Deputy Sterling had a oral conversation with Ray Sandrock where he authorized and requested that he issue a trespass warning for violation of the rules that Deputy Sterling observed that occurs in his presence. Exactly what happened here. The rest, I don't think, really requires a whole lot of comment. I want to hit the high points, the matters that I think would be relevant for you to consider and rebut his items. The other I would just be repeating, because the only other thing I would say, there was no dispute during any of this that Mr. Kesselring was recording. He clearly, there's no doubt that he was recording, and the fact that the one other part that we heard was, well, he appears to be raising an issue that Mr. Winterkorn is a public official and has a right constitutionally. Maybe not. I'm not going to concede it, but even if Mr. Winterkorn is deemed to be a public official under his interpretation, he was still videotaping from the moment he walked in the county administration building to the time he walked in Mr. Winterkorn's office, and that videotaping in and of itself is improper under the rules. So, putting aside whether Mr. Winterkorn's a elected public official, irrelevant. He's still videotaping, prohibited. So, the trespass should be upheld. Thank you.
Okay. I will have my written decision within 7 days.
Thank you, Your Honor. Thanks for taking so much time. Sorry.
When I go through the listen to it, and I can, and I can close it. But, the one thing is, I don't know if it's already emailed,
Yeah, we're calling it down.
but if not, if you could